Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Welcome to SCOTUScast, a product of the Federalist Society's Faculty Division. I'm your host, Nick Garfinkel. On June 21st, the Supreme Court decided Carson versus Makin. In a 6-3 opinion, the court reversed and remanded the judgment of the U.S. Court of Appeals for the First Circuit, holding that Maine's nonsectarian requirement for otherwise generally available tuition assistance payments to parents who live in school districts that do not operate a secondary school of their own violates the Free Exercise Clause of the First Amendment. Joining today to discuss this case and its implications is Arif Panju, Managing Attorney at the Institute for Justice.
It's an honor to be with the Federalist Society once more. I'll just take a moment of personal privilege just to thank the FedSoc. It was profoundly important to me in law school at SMU Law, and it continues to be profoundly important today. And I'm looking forward to discussing Carson v. Makin. Before I jump into the opinion, I think it makes sense to kind of set the stage a bit, because over the past 30 years, private school choice programs have expanded across this country. And during those 3 decades, opponents of school choice have attacked educational choice programs in 2 ways. And I think laying out both of those methods of challenging educational choice programs helps frame what was at issue in Carson v. Makin. First, around in the early 1990s, opponents of educational choice and these are programs that allow parents to select from an array of private educational options, including religious schools, an educational option that works best for their child. And opponents of these programs argue that such programs violated the Establishment Clause of the United States Constitution. The U.S. Supreme Court put an end to that in 2002 in a case called Zellman v. Simmons-Harris, and held so long as a program is neutral as to religion and operates on private choice, meaning parents have a range of options to pick from and it's their decision, it's perfectly fine to have a school choice program and does not offend the Establishment Clause. With that arrow gone, opponents turn to challenging private school choice programs on the grounds that they violated state law, that prevented the funding of religious schools or religious institutions, and also under state constitutional provisions, often called Blaine amendments, which prohibited the same. The court addressed this type of challenge directly in Espinosa v. Montana Department of Revenue, which I'll get into because it's discussed in Carson, and Carson relies heavily on Espinosa and its principles. The court rejected kind of gerrymandering along religious lines and discriminating against educational options just because they're religious as a violation of the Free Exercise Clause. Carson v. Makin was filed shortly after Espinosa in 2018, and together with Espinosa, has extinguished this second line of attack against school choice. At the end of Carson v. Makin, I'll discuss some of the broad implications of what that means across the country and for school choice specifically. And so in Carson v. Makin, there's a law at issue, and it's a law that's been on the books for a very long time, actually a program that's been on the books for a very long time, a tuition program. And the state of Maine, which is the most rural state in the union, allows parents if they live in a school district, which is, the opinion refers to these as school administrative unions or SAUs. But if they live in a school district that does not operate its own public school, the tuitioning program allows parents to apply and get the tuition benefit and send their child to a school of their choice, public or private, in the United States or out of the United States, within Maine or anywhere in the other 49 states. It doesn't matter. You can pick the school of your choice as long as it's approved, so long as it's not a religious school. Before 1980, and again, this program's been on the books for over a century, and before 1980, families in Maine were perfectly able to pick a religious school if that's what they wanted. After 1980, after an AG opinion was written, and this was later codified shortly thereafter, the Attorney General of Maine at the time invoked the Establishment Clause as the basis for no longer allowing parents to pick religious schools. And despite Zellman coming down in 2002, Maine continued enforcing its sectarian exclusion to prevent families who otherwise qualified for the program from picking a school of their choice that was religious. And this religious exclusion, and I'll refer to it as the religious exclusion, provided that you can't pick a school that is sectarian. That's just a no-go in Maine. And the provision had been challenged a couple times before Carson, and those challenges fell short, but not after Carson. And so it's important to note that we were in the trial court in Carson. We knew that we were going to hit a wall, which was the prior case that had rejected this exact same argument, that excluding parents from picking a religious educational option violates the free exercise clause. And so we were poured out in the trial court. And while in the First Circuit in Carson, a case challenging Montana's exclusion of religious educational options from its school choice program, they're a tax credit scholarship, that ruling, Espinosa v. Montana, came down after we argued the case. And there, SCOTUS held that the religious exclusion in Montana, and there it was enshrined in its Blaine Amendment that the Montana Supreme Court was enforcing and saying, under a state constitution, you simply can't pick a religious school. The High Court, the US Supreme Court, ruled that Blaine Amendment violated free exercise because it discriminated against religious status and just singled out religious educational options and discriminated against them. When that decision came down, Espinosa v. Montana, Carson had been argued in the First Circuit and was waiting for a decision. So what did the First Circuit do? Well, we sent 28J letters, and then Maine changed its tune, saying we don't discriminate against religion because it's religious. We discriminate against options that are religious if they use religion. And so the First Circuit seized on the distinction between, so-called distinction between religious status and religious use. And in addition to that, also reasoned that the tuition benefit is not like other school choice programs. It's just the, quote, rough equivalent, end quote, of a public school. And it's simply available to people that don't have access in their own town to a public school. Seizing on these two distinctions, the First Circuit, with, I think, Barron, Celia, and Justice Souter sitting by designation, applied rational basis review and upheld the religious exclusion under Maine statute. Now, again, Maine had argued in the First Circuit that if a school is religious, it is out. And after Espinosa changed its tune, the First Circuit also seized on the status use distinction primarily, and also redefining the benefit as the rough equivalent of a public education. And so the First Circuit upholds the exclusion, and the US Supreme Court grants cert in Carson. And on June 21st of this year, issues its decision and reverses. Carson is a 6-3 decision with the majority opinion written by the Chief. And Chief Justice Roberts, it's interesting because the Chief authored both status discrimination cases that preceded Carson. The first being Trinity Lutheran v. Comer, and the next one, which was the case I just discussed, Espinosa v. Montana Department of Revenue. And Supreme Court reverses the First Circuit and holds that the religious exclusion baked into the tuitioning program that prevented families like the Carsons and the Nelsons, families that the Institute for Justice represented along with First Liberty Institute, that they have a right to pick a school of their choice. And by preventing them from picking a religious school, their free exercise rights were violated, and the court reversed. And so I'll march through the majority opinion because it's, one thing that I think I take away from it is just, it's an understated opinion by the Chief. And I think it really distills the fact that this area of the law is quite clear. And so the majority opinion begins by laying out some principles. And I'll start there. The first is that the free exercise clause of the First Amendment, the free exercise clause of the First Amendment protects against, quote, indirect coercion or penalties on the free exercise of religion, not just outright prohibitions, end quote. And there it's relying on Ling v. Northwest Indian Cemetery Protective Association, a 1988 case. The next principle it lays out is that a state violates the free exercise clause when it excludes religious observers from otherwise available public benefits. And that's Sherbert v. Werner, 1963. And for instance, a state can't withhold unemployment benefits, the court explains, on the ground that an individual lost her job for refusing to abandon the dictates of her faith. So after laying out these principles, the court then turns to explain that it has recently applied these principles in the context of two state efforts to withhold otherwise available public benefits from religious organization. The first is Trinity Lutheran, and the next one is Espinosa. The court explains that like the state of Missouri and Trinity Lutheran, and like the state of Montana and Espinosa, the state of Maine is singling out individuals from a public benefit program because of their religious exercise. And then it proceeds to march through those two cases. In Trinity Lutheran, in the entire case is Trinity Lutheran Church of Columbia v. Comer, the state of Missouri offered grants to pay for playground resurfacing. A lot of older playgrounds, if you remember, are pavement and they're hard. And some of the newer playgrounds that our little humans get to play on are not. They often have a very padded type surface made with recycled tires. That's the type of program that was at issue in Trinity Lutheran. And the state of Missouri offered grants to pay for playground resurfacing. But it maintained a policy of denying the grants to applicants that were either owned or controlled by a religious entity or a church. And the majority opinion in that case deemed it, quote, unremarkable, end quote, in light of the court's prior decisions to conclude that the free exercise clause did not permit Missouri to expressly discriminate against otherwise eligible recipients by disqualifying them. The court held that such discrimination was odious, its word, to the Constitution. Now, 2 terms ago, the court decided Espinosa v. Montana. And in Carson, the chief, after going into Trinity Lutheran and showing how the principles that were laid out earlier applied in that case, marches through Espinosa v. Montana to explain why it reached the conclusion it did in that case. So in Espinosa v. Montana, the court reached the same conclusion as it did in Trinity Lutheran. And there, the program involved a school choice program that provided tax credit scholarships to families in Montana to help offset the cost of private education. Miss Espinosa wanted her children to go to religious schools and was met with hostility. The Maine Supreme Court held that the program at issue in Espinosa, to the extent it included religious schools, violated the state constitution's Blaine Amendment. Blaine amendments are constitutional provisions that bar government aid to any religious schools. They're peppered throughout several state constitutions around the country. And as I mentioned earlier, they form the second line of attack, really, against school choice programs, both at legislatures and in the courts. And in Espinosa, the court granted cert and reversed and held that the free exercise clause forbade the state of Montana from denying Espinosa and any other parents like her from picking a religious school because it was a violation of her free exercise rights to do so. So back to Carson. So as you can see, the chief just lays out some principles, marches through Trinity Lutheran to illustrate how those principles were applied in that case, goes through Espinosa, explains how the principles applied in that case. Espinosa, like Carson v. Makin, both involve educational choice programs, both involve a benefit that the challengers were eligible for, but that they could not use because what they were trying to do is educate their children at religious schools because the parents believed that that was the best educational option for their children, and the state had given parents the decision-making power to say, this is where we want to go with our students under this program. And so after discussing Trinity Lutheran and Espinosa, the majority in Carson then declares that the, quote, unremarkable, end quote, principles applied in both of those cases suffice to resolve Carson. Maine offers its citizens a benefit, the chief explains, tuition assistance payments, but conditions the availability of those benefits on religious grounds. Now, the court explains that while the wording of the Maine statute at issue and the wording of the Maine Constitution's Blaine Amendment are different, and they are different, the court concludes that their effect is the same, because it is, to disqualify some private schools. And that's it. and from funding that folks would be generally available to use, and disqualifies them solely because they are religious. Such laws, the court declared, must satisfy strict scrutiny. Recall that the First Circuit had applied rational basis review to uphold Maine's exclusion after Espinosa came down. So the court having decided in Carson now that strict scrutiny applies, and having laid out the principles for how it decided both Trinity Lutheran and Espinosa, and then applying those principles and explaining how they applied in those two cases, the court turns to addressing the First Circuit opinion. And in particular, the two ways that the First Circuit and Maine, after Espinosa came down, attempted to distinguish Espinosa, and finds that both fall short. And the court opens up this part of the analysis by reiterating what it concluded in Zelman v. Simmons-Harris in 2002, that a neutral benefit program in which public funds flow to religious organizations through the, and this is key, the independent choices of the private benefit recipients does not offend the Establishment Clause. That's been put to bed, and Maine's decision to continue invoking anti-establishment concerns, not only in 1980, before Zelman, when it first decided to prevent parents from picking religious schools, but even after Zelman came down, its decision to continue excluding religious educational options from its program after Zelman, quote, promotes stricter separation of church and state, end quote, than is required under the Constitution. And as a result, since they decide to go farther than what's required, such anti-establishment interests cannot qualify as compelling under strict scrutiny, and especially in the face of the infringement of free exercise. The court also, in this part of the opinion, addresses one of the dissents, and I'll touch upon them at the end, Justice Breyer's, but also Sotomayor, and Breyer was really stressing the importance of religious neutrality in his dissent. But here the majority explains that there's nothing neutral about Maine's sectarian exclusion. It is discrimination against religion on its face. It's not neutral. And its pattern of continuing to enforce the exclusion, despite coming down with the Supreme Court coming down with Zelman v. Simmons-Harris in 2002, continuing to enforce it after Trinity Lutheran came down in 2017, I think, and after Espinosa with its pivot that it's not discriminating against religious schools because they're religious, but only because they do religious things, the status use distinction. The fact that they want to continue invoking their anti-establishment concerns doesn't justify a compelling governmental interest. It's discrimination here. And there's nothing neutral about that. So the majority opinion here in Carson kind of starts addressing the dissents. And there are two ways that the First Circuit attempted to distinguish the court's precedent by both the status use distinction that I mentioned earlier, but also by recharacterizing the nature of the benefit, the tuition assistance program. And so recharacterizing the benefit is really the first way that the court addresses, the first distinction that the court addresses. Now recall the three-judge panel in the First Circuit first argued that, hey, this is a reason that this is not a school choice program. It's rather a benefit that provides the, quote, rough equivalent of a public education. You see this in Sotomayor's dissent. The benefit is public education. And so that's one line of reasoning that's rejected by the Supreme Court's majority opinion in Carson. The second one is defining the nature of the religious exclusion as one based on religious use and not status. So the court first jumps into the first one, which is recasting the benefit as a rough equivalent of a public education. And the chief points out that first, just looking at the statute, which says that families can use a tuitioning law at any public or private school, that the tuitions, the statute says no such thing, that this is simply a rough equivalent of a public education. It is a benefit that provides tuition at a public school or approved private school, and that can be in Maine or out of Maine. And so the statute itself doesn't support the distinction just right out of the gate. Next, the chief turns to the many, many differences between public schools and public education and private schools. And that according to Maine, the only difference is religion. Maine is saying it's a rough equivalent because the only difference really is that, we want everything to be secular. And so that's why we're excluding religious educational options, because these private schools that parents pick are really just a rough equivalent of a public school. And so we can exclude religion. And so the chief marches through the numerous ways that private schools are not like public schools. First, they don't have to accept all students. Second, they charge tuition. And as the record revealed, some of the schools that parents pick charge a lot more tuition than the tuition benefit. Some charge a little bit less, but many charge more, especially a lot of some of the high-end, really expensive prep schools that charge, north of $50,000 a year. And Maine families that qualified for the program could and did select such schools. And that's not a rough equivalent. And no one would be confused that going to a $50,000 private school in New Hampshire is the rough equivalent of a Maine public school. Some more differences. The curriculum needs didn't have to resemble a public schools. The two schools that the parents, the Carsons and the Nelsons, wanted to send their children to were accredited by a New England organization that accredited private schools. And Maine statute made clear that if the school you want is accredited by this organization, your curriculum doesn't have to resemble anything that a Maine public school has to resemble. There's no annual state testing. Schools that participated in the program were not required to hire state certified teachers, and parents were free to pick single-sex schools. Those were permitted as well. And so private schools are not the, quote, rough equivalent of a public school education. After going through the many ways that they're different, the chief concludes that the only equivalence between these private educational options and public education in Maine that Maine is striving for here under the program appears to be just based on religion, just drawing a line at religion. And so the court doesn't find that distinction persuasive. Rather, it simply amplifies the reality of what's going on in this case. And that is that by recasting the benefit, what Maine's really doing, and what the First Circuit did, is really just recast the formulation for why this exclusion violates the free exercise clause. It's because it targets religion. You can explain it in different ways, but it all ends at the exact same point. Picking students that want to pick a private school that the government thinks is fine, that's okay. But if they pick a religious school, that's not okay. And that's really the only line that existed, regardless of the fact that Maine and the First Circuit attempted to recast the benefit of the tuition benefit as a substitute for public education. So having dispatched that, the majority opinion then turns to the second way that Maine and the First Circuit attempted to avoid Espinosa and uphold the religious exclusion under Maine's tuitioning program. And that is the status-use distinction. Now, it's important to note that Espinosa and Trinity Lutheran before it were status cases, as I mentioned earlier, and the chief wrote the majority opinion in both. And in those cases, the funding restrictions were, according to the First Circuit and according to Maine, were simply status-based discrimination, and that's not what's happening here. After Espinosa came out, Maine took the position that religious schools could qualify if they want, once they go through an inquiry by the state of whether they're using the funds for religious education or if they're using the funds to teach topics like math through the lens of religion. Think of hypotheticals involving Noah's Ark to play math and addition exercises. That's what Maine was attempting to cast its exclusion as an attempt to just ensure that religion is not used at all with these funds. Now, the court rejects this outright. First, it starts with Trinity Lutheran and Espinosa and makes clear that it never suggested that use-based discrimination is any less offensive to the free exercise clause. Those were status cases, but nothing in those cases support the idea that use-based discrimination is permissible. The court then moves to Carson, where the majority illustrates why, and says the following, and I think this is important. Quote, educating young people in their faith are responsibilities that lie at the very core of the mission of a private religious school, period, end quote. And that's directly out of Our Lady of Guadalupe School v. Morsi Beru in 2012. And the court explains that giving effect to such a distinction between religious status and religious use by scrutinizing whether and how a religious school pursues its educational mission would also raise serious concerns about entanglement with religion. And that's what Maine was saying, that these religious schools can participate after it inquires into how religious they are. There was a school that they did this to that ultimately was allowed to participate, Cardigan Mountain School, but only after a 4-month inquiry into why there was a chapel, what went on there, and after the state of Maine determined that the values that were taught at that school were universal enough that it was permissible and parents could pick that school as an option. That school charged a lot more than tuition benefit, but they could pick it. Maybe that works for Cardigan Mountain, but good luck if you're the Jewish day school, Catholic schools, or Christian schools or Muslim schools. And that's where the court is getting at, that if you're going to allow the government to inquire into how religious schools are and spend months delving into that, that raises serious concerns about entanglement. And you can't do that, is where the court comes down here with the majority opinion. On status and use, the majority opinion in Carson says unequivocally that the distinction lacks a meaningful application, not only in theory, but in practice as well. And so it dispatches those two attempts to distinguish Espinosa and Trinity Lutheran, and then the majority opinion turns to Locke v. Davey. Doesn't spend much time on Locke v. Davey, but Locke v. Davey is another case that the First Circuit relied on and that Maine invoked to justify excluding religious educational options from its educational choice program. And the court is not buying it. Maine and the dissents invoke Locke in support of the argument that the state can preclude parents from designating a religious school to receive tuition. And in Locke, the state of Washington had established a scholarship for post-secondary students, and Joshua Davey was excluded from the endeavor that he was pursuing, and that is he was studying and training to join the ministry. And the court in Locke said that having this kind of program is fine if you exclude, quote, essentially religious endeavors, end quote, such as, quote, training a minister to lead a congregation, end quote. And the court upheld the restriction in Locke v. Davey. But Locke, as the majority in Carson explains, offers no help here to the state of Maine. And it cites the reasons that it had previously cited both in Trinity Lutheran and in Espinosa when it had to deal with Locke there. Locke is confined to preparing for the ministry. Taking theology classes, the majority opinion notes, in that program, in the Locke case, was fine. It's just that if you're pursuing the ministry, and that's where the end game was, that restriction was upheld because Locke's reasoning was just that, looking at historical, and it found a historic and substantial founding era interest against using public money to support church leaders. But there is no historic and substantial tradition, the majority opinion in Carson found, against aiding private religious schools. And that's the exact same conclusion it reached in Espinosa when it dealt with Locke there. Locke cannot be read beyond its narrow focus on vocational religious degrees. And that's what Carson had to say about Locke. And it didn't spend too much time discussing it. And at the end, the court reiterates and concludes that Maine's sectarian exclusion violates the free exercise clause, and parents like the Carsons, parents like the Nelsons, just like any other parent that has a school choice program available in their state can and should be able to pick a religious educational option. And in Carson, the U.S. Supreme Court made clear that it is because their free exercise rights allow them to, and preventing them from doing so violates the free exercise clause. So I'll touch on the dissents just briefly, and after the dissents, I'll talk about impact that I believe we'll see in the wake of Carson v. Makin. So there's two dissents, and before I jump into dissents, I think it's worth noting and reiterating in part a couple of things. Now, the program in Maine has been on the books since the early 19th century, and for over a century, families could and did choose religious schools. It wasn't until 1980, with an AG opinion, that relied on an incorrect interpretation of the Establishment Clause, which was confirmed in 2002 by the U.S. Supreme Court in Zellman, that the AG thought you just couldn't pick religious schools. Maine continued enforcing its religious exclusion after Zellman, citing anti-establishment concerns. You fast forward to Trinity Lutheran in 2017, despite SCOTUS holding that you can't withhold a public benefit due to being a religious entity, Maine kept at it. And again, after Espinoza, in the context of the Carson case, Maine changes its tune once more. Why? To keep pressing forward and excluding religious educational options. So having that as the setting the table for the dissents, I turn first to Breyer's dissent. Now, Breyer argues that this is a swan song to the Establishment Clause. He's been writing about this since, for a long time, including in Zellman v. Simmons-Harris. And Breyer argues that allowing Maine's program to provide families with the option, if they so choose, to pick a public or private school, including private schools that are religious, will lead to religious strife if they do so, and if religious schools can participate equally and with public schools. And again, this is about parents picking schools that they want. Now, the religious strife that Breyer is concerned about, will not happen, and that's because it did not happen. As the majority opinion explains, since the early 19th century, families chose religious schools. It wasn't until 1980 with the AG opinion, and again, there was no issues there. It was just that the AG cited the Establishment Clause and his reading of the Establishment Clause, which was later codified. And so, overnight in 1980, there were schools that had to pick between maintaining their religious identity and facing the prospect of having kids just be left with nowhere to go to school, or to eschew their religious identity and to maintain the educational option to take care of the students that were enrolled there. There's a amicus brief that discusses the experience of John Baptist High School and goes into that. And hundreds of students were picking religious educational options. And what Breyer, what he seizes on is that if there's over 100 religious denominations in this country with different belief systems, and Breyer argues that we can justify expelling religion from the program so that these denominations will not fight with each other. And again, that wasn't happening before in Maine. But the fact that so many, and frankly, the fact that so many religious denominations exist, it confirms that we are a pluralistic society. And I'd point to a really nice amicus brief by Professor Berner out of Johns Hopkins, written by, I think, Dominic Dre, a fellow FedSoc colleague, that really, kind of touches upon the pluralistic society we live in and educational options. And really, the way to preserve it is to ensure that the Constitution is enforced. The government cannot favor religion, but it cannot, as the chief said, disfavor religion. And that's what the religious exclusion did. And so Breyer's dissent really focuses on the Establishment Clause, focuses on his view of it, which he's been pronouncing since and even before Zellman. But as the court explains in the majority opinion, Zellman put that issue to rest. When parents have a choice, an independent choice, and can pick from a variety of options, there is no establishment problem with that. Turning to Justice Sotomayor's dissent, Sotomayor's dissent is shorter, but it hits on 3 points briefly. It criticizes the court and says you shouldn't have gone down this road starting in Trinity Lutheran. Recall, Trinity Lutheran was a 7-2 decision. The two dissenters were Sotomayor and Ruth Bader Ginsburg. It was a narrow ruling that carried 7 justices, but Sotomayor is criticizing it and saying the court shouldn't have gone down this road. Why? Leads to her second point. That's because she's criticizing the court for failing to apply the play in the joints principle, and says, that begs the question, what's left of it? And then pivots to her third point, where she follows the First Circuit's characterization of the benefit here and says the benefit is public education. And as I discussed earlier, the chief marched through the many, many reasons why picking a religious school anywhere in the United States or even outside the world, or even schools that are single sex or cost a lot of money or that don't have to accept everyone or that don't need state certified teachers, those aren't the rough equivalent of a public education. Those are private schools. And as Our Lady Guadalupe says, private schools that are religious in nature do teach through a lens of religion. And that's fine. That doesn't raise any issues here, if the parents decide that that's the best option for them and their children. Sotomayor also criticizes the majority and asserts in Carson that Maine must fund and quote unquote religious education after Carson, and that it was quote forced upon the state. The chief addresses this and rejects this in the majority opinion and notes that it is Maine that chose to allow some parents to direct the tuition benefit to private schools. They've done so for over a century. It wasn't forced. The state, per the majority opinion, could expand the reach of its public school system. It could increase the availability of transportation. It could increase remote learning, allow flexible attendance policies. But what it cannot do is discriminate along religious lines to allow parents to pick some schools, but not schools that they think are best suited for their child, religious schools. So those are the two dissents from Breyer and Sotomayor. Finally, I'll end with the impact of Carson. The immediate impact is for parents like Dave and Amy Carson and the Nelsons who desire religious education and will have access to using the tuition benefit for the first time. It's worth noting that Dave and Amy Carson's daughter graduated while the case was up, and they kept pressing forward because they believed that this was an important thing to do to protect not only their free exercise rights, but everyone else's. The Nelsons, who have a son that is at a religious school, and the Nelsons were faced with using the benefit at a school that was not religious or paying, and they couldn't afford a religious educational option. So their son was going to a school that they didn't think was the best for him. They wanted a religious school. The Carsons faced a different type of injury. They had to pick between the benefit, like the Nelsons, or paying out of pocket. The Carsons could afford to pay out of pocket and did, and then had to forego the benefit. That just kind of distills the impact of the religious exclusion on people who simply want to pick a religious educational option for their child. The other immediate impact is in Vermont. There's a case in Vermont right now challenging a very similar religious exclusion. There's a stay in that case in light of Carson, and parents there too, because Carson will be dispositive. In that case, will be able to pick the religious educational option if that's what they choose. Taking a step back and looking at the broader impact nationally, most states, when adopting educational choice programs, are neutral towards religion. But in some states, whenever a legislature considers expanding an educational choice, like here in Texas, where I'm at, the opponents of choice, often teachers' unions and the like, will run to the legislature and invoke the state's Blaine Amendment as a weapon to create a cloud of uncertainty over the program, or a state statute that prohibits, similarly, the flow of public funds to a religious school. And if that doesn't work, they go to court, but no longer after Carson. That is the area in which this decision in Carson v. Makin will have the most impact nationally. Any Blaine Amendment or statute to the contrary is off the table after Carson. And so just like after Espinosa, where we saw the expansion of existing school choice programs and new ones hitting the books, we expect the same thing to happen after Carson, which bookends Espinosa and makes clear that in the educational choice context, much like the court has done when it established principles leading to Trinity Lutheran and everything that came afterwards, like Espinosa and now Carson, states, once they give a choice to parents, can't eliminate religious educational options from the menu of options that they have without violating the free exercise clause.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.